Yield myself just a moment to indicate that the highest maternal mortality is among women of color,
Point of
particularly
order.
African American.
Point of order,
women.
Madam Chairman. On whose time is the chairman speaking?
Mine, to correct the record. I'd like to yield to the gentleman, Mr.
You don't have
Stanton, for
time,
5
Madam
minutes.
Chairman.
Thank you, Madam Chair.
Thank you.
And I want to thank our witnesses for joining us here today and your patience with a long day up here on Capitol Hill. Your testimony today is crucial for the work of this committee and for our Congress. Every person deserves access to reproductive health care that is safe and affordable. It is a fundamental constitutional right recognized by the United States Supreme Court now for nearly 50 years. Unfortunately, since Roe versus Wade was decided, too many state governments across our nation have set their sights on eliminating this constitutional right. In states like mine and Arizona, legislatures and governors have chipped away at it, inserting their own personal views into conversations between a woman and her doctor and setting up roadblock after roadblock. In Arizona, in order to obtain an abortion, the state law requires people to visit their doctor twice, 24 hours apart, to be read a government-mandated script, and obtain an ultrasound, all obstacles that do not prioritize health or safety. And what's more, Arizona is one of 9 states that still has pre-Roe abortion ban on the books. Now, emboldened by justices appointed to the Supreme Court by the previous administration, some states have gone even further, attempting to effectively ban abortion completely. That's what happened in Texas, where Senate Bill 8 has sought to see this fundamental right stripped away, and in Mississippi, where the legislature has passed a facially unconstitutional law with the expressed intent of challenging Roe. These are laws that affect every state because I have grave concerns that the protections of Roe and its progeny may be erased by the Supreme Court. It's one of the reasons that I co-sponsored and voted for the Women's Health Protection Act, which would enshrine a woman's right to choose in federal statute. What we know is that these anti-choice laws disproportionately affect low-income communities and communities of color. If Roe were overturned, Arizona would become one of several states where abortion was outlawed, and my constituents would no longer have access to the reproductive health care that is their right. I have a question for Dr. Moetti. Doctor, how do excessive restrictions force providers to go against their expert medical judgment and prevent them from providing the very best care possible to their patients?
Thank you so much for that question. I have so many examples of how these restrictions impact evidence-based care. So in Texas, we have a law that requires that I provide medication abortion per the FDA label. There is no other area of medicine where a state law requires following an FDA label. This becomes problematic because the second medication used in medication abortion, misoprostol, can be taken in different ways. The FDA label says that it has to be placed in the sides of the cheeks, but that medication can actually be swallowed, it can be placed under the tongue, or it can be placed in the vagina and also works in the process. But because of that law, when I have patients with unique medical conditions that might prevent them from taking that medication orally, ordinarily, I would recommend that they take that medication vaginally. And when I practiced in Hawaii, that's what I would do. I would tell them to take the medication vaginally. So for example, if someone has Crohn's disease or IBS, they might not want to take it orally, they would take it vaginally. But in Texas, I can't tell them to do the best thing for their health in that process because the state restricts evidence-based care. So that's one example right there. The state has just passed, or the Fifth Circuit has upheld a ban on second trimester procedures. And so now once hopefully SB 8 is overturned, the state actually tells me how to operate. So there's nowhere else in my gynecologic practice where the state would tell me that you need to do the hysterectomy like this, that you should put the clamp here and you should do the incision there. That's not how we practice medicine at all. But now I'm at risk for a criminal penalty for doing a procedure in the wrong way, the way that the state doesn't want me to do. This doesn't make any sense.
Thank you.
The state.
I really appreciate that answer. I have 30 seconds left. Professor Bridges, I did want to give you one additional opportunity to respond to anything one of my colleagues may have said earlier that you would like to respond to.
Yes, thank you again for the opportunity. I would just encourage Representative Owens to Google racial disparities in maternal mortality and morbidity. I've actually written an article about that. It's in the new NYU Law Review. It gives you a lot of information about how it's dangerous to undergo childbirth. And I would just like to just note for the record that there were a lot of fact-free claims that Representative Owens made. Wealthier people don't have abortions because wealthier people love their children. It's just the fact-free level of his claims were remarkable.
Thank you, Professor. I yield back.